And the first one is another question we've never hit on the show, and it was a really heartfelt email we received from a young lady who said, Carmen, I'm thinking about filing bankruptcy. I can't afford an attorney. I've been to several law firms, including your own, and I've been quoted a price, and I can't find the money to do it. And I wanted to know if I should use a bankruptcy petition preparer. Be really careful here, folks. Let's start with it. I understand money's tight. I really do. And there's no such thing as a easy bankruptcy case. There's really not. What you have to think about is who this is really important to. Is it really important to the attorney? Is it important to the trustee? Is it important to the creditors? It's important to you. And you're going to have questions throughout the process. It reminds me of that commercial where the lady is making fun of her husband because he bought software from a box, and she's like, why don't you, instead of calling H&R Block with your tax questions, why don't you call the box? That's the same thing with the petition preparer. Petition preparer's role is to type a document. You're telling them what to type. Courts take a very harsh courts take a very harsh look at petition preparers. The United States Attorney takes a very harsh position when it comes to petition preparers. Petition preparers are not allowed to give legal advice. They're not allowed to tell you where to put things in the paperwork. And the bankruptcy paperwork's usually about yo thick. They're not allowed to tell you which documents you need, which documents you don't. And most importantly, when you have questions, a bankruptcy petition preparer cannot answer them for you. That's one of the biggest reasons a person hires an attorney. Advice. You want to know before you file what's going to happen. You want to know what the predicted outcome is going to be, and you want to be substantially certain that you've got somebody by your side to go with you to the meeting of creditors, to be there to answer your questions afterwards, and to help you get back on the road to recovery. That's really important. And of course, if something happens during the proceedings, you want to rely on them for whatever happens. I mean, let's say, for example, one of your creditors files a lawsuit against you, or the U.S. trustee shows up at the meeting of creditors or phones in and has questions. You want to make sure that your attorney's there with you to deal with this. Likewise, let's say, for example, there's something wrong with your paperwork. Well, you can't just call the box. You can't call the petition preparer. You're going to have to deal with this on your own. So now going back to the beginning, is it expensive to hire an attorney? Some people would say yes. Some people would say it's the best money they've ever invested. I sit here and say, this is what I do for a living. I try to make it as inexpensive for people as possible. The problem is Congress, in the 2005 amendments, put, I'd say, rather ridiculous requirements on me, which cost you more money. And I have to pass those costs on to the client. I mean, I wish I could do bankruptcies for free. I would help people get through the system, but at the same point in time, that's not feasible. So what happens? Congress puts these ridiculous requirements on me. I've got to pass the cost along. That's why the cost went up from what it was 10 years ago. I mean, when I was doing bankruptcies when I first started 15 years ago, for a third of what we're doing them now. I mean, and there's really no reason for the cost to be so high, but it is because we have a Congress in Washington who's watching out for your consumer best interest. They're watching out for you. So watch your back. So no, the cost of a bankruptcy petition preparer, it could cost you more in the long run. I remember having a conversation with the bankruptcy trustee, Diane Jensen. Her and I have been friends since I started doing this 15 years ago. She is a very tough trustee, no doubt about it. But she even tells people who file bankruptcy on their own, go hire an attorney. Her job is to go after assets which are not protected. But if a person's not maximizing their exemptions, meaning using attorney's advice and consent to protect assets, her job is going to be to take them, sell them, and give the money to the creditors. And she knows that in her office that she sees things that should not and didn't have to happen to people who didn't hire an attorney. So I don't know. I understand money's tight, but at the same point in time is what if what would be the results if you did, and what would be the results if you didn't? If there's no economic benefit for you not to hire an attorney, then you don't. If there's an economic benefit for you to hire an attorney, then you do. So I will leave that one as that.